defendants.
And why do you put L here? Look at this. Come on, put this thing right. So the kind of mistakes I don't like. You say you are with who? Gigi Okoro. You say you are with who?
Gigi Okoro, double G Okoro.
I know, you are with who? You are with who?
M.I. Oshemeli.
Okay.
For the defendants.
Got the gen? Yes. But there is snipper now. Yes. Okay. Okay. What is that?
Yes. No. Cut the video, go here back here. George. Let me go to the team. I'm not working. I can, and I'm going to do it. Okay.
What is going on? Okay. Okay, this is my judgment. I have carefully considered the processes filed and the submissions of the parties.
Four o'clock now start. Bịa ka ịbụ lọya ndị ọzọ bịara.
We had the power of
network at this wrong.
I'm gonna check.
It's on. It's on here. What do you mean by on? It's on. Is this on? You say this is main on here. Why do you say it's on? The ground upon which the said application is brought is that the claimant's suit is statute barred by virtue of the provision of Section 18 and Section 20 sub 1 of the limitation laws of Delta State, Cap 127 laws of Delta State, that the claimant instituted this suit against the defendants after 5 years that this court lacks jurisdiction to entertain this suit. Cited P. Oil Corporation Nigeria Limited, Military Administration and Administrator and another versus Aladeyelu and others, CRAM Limited versus Ekiti State Government, and Nwokoro versus Onoma. To the claimant, course of action is not statute barred, having been reviewed by the acknowledgement and subsequent purported compensation payment of 2 million naira to claimant by the defendant, that it is the inadequacy of the purported compensation is what has necessitated this extant suit. Cited Attorney General of the Federation versus Attorney General at Bia State, and Azie versus Azie and others. Cited the case of Kokorin versus Patigi local government. Into it sometime.
I'm the one at the corner, they bring you down.
Yes, we are also having challenges with network, but I think we can do better now. Yes, for the purpose of limitation of time for action, time begins to run from the moment the course of action has arisen. That is, when the facts which are material to be proved to entitle the claimant to succeed have happened. See Lasisi versus Federal, Lasisi Federal versus Attorney General of Oyo State. The claimant argued that although Section 18 and 20 sub 1 of the limitation laws of Delta State provides as a general rule that actions founded on tort must be instituted within 5 years after the accrual of the course of action. The said law also admits some exceptions where the computation of time can be reviewed and the course of action can accrue afresh. Cited Attorney General of the Federation versus Attorney General Abia State, and Azir versus Azir and others, Supra, that the defendants, via their letter of 16th April 2019 to the claimant, stated in part thus: 6, that arising from the said accident resulting in 3 survivors, our client rose to the occasion to compensate the 3 said persons, including your client. Steps taken were as follows. B, that on resigning, our client paid a bulk sum payment of 2 million naira, covering variegated present and future payment till the year 2022. Close of quote. The claimant respondent submits that the above correspondence reviews the course of action under Relief 2 of claimant's claim. He cited the case of Coloring versus Patigi local government.
Come and remove audio from me. Remove video. You don't want video. Okay, it's in. No, no, the same thing. Pick my phone.
continue. What about this slide? Yes, we are having some network challenges. That is why we are trying to get through it. In Mr. Daniel Tiebogren versus the governor of Delta State and others, the citation is in the judgment. The Court of Appeal heard per Saulawa JCA does. I'm quoting him now. Instructively, one of the salient exceptions to the general rule of statute of limitation is that where there is an admission of liability, the course of negotiation between the respective parties, substantial and equitable justice demands that the action should not be allowed to be statute barred after the expiration of the statutory prescribed period. C. Godwin Inyang versus Registered Trustees of the First Century Gospel Church. C. Noku and another versus Commissioner for Works, Housing and Transport. Aremo, the second versus Adekaye. Dr. D. Nwanko and another versus Nwanko. Lawal and others versus Executive Governor of Lagos State and others. The citations are in the judgment. Having considered the submissions of the claimant and the defendants and the authorities cited by them, I am persuaded that this suit falls within the exception to the limitation law of Delta State, where there is an admission of liability during negotiation, and part of the process is the fulfillment of the agreement, then the demands of justice and equity will not allow the claimant to be barred after statutory period of limitation. In the circumstance, the application of the defendants that the court strike out or dismiss this suit for want of jurisdiction is not grantable. It fails and so is hereby dismissed. The defendants called to question the admissibility of Exhibit CW1/3 and Exhibit CW1/9, and same ought to be expunged from the court records. Exhibit CW1/3 is bank statement of account from FCMB, Access Bank, EcoBank, Union Bank, while Exhibit CW1/9, which is described as email, printout, linkedin.com, that same is a computer-generated document. That the claimant did not comply with Section 84(1), 2, and 4 of the Evidence Act 2011. To the defendant, a party who seeks to tender in evidence a computer-generated document must plead and give evidence in relation to the computer that produced the said documents, and some must be called to establish the conditions set out in Section 84 sub 2 of the Evidence Act 2011. The defendants also cited UBA PLC versus Agana Bonton versus another and another, Nwaogu versus Atuma and others, Dixon versus Sylvia. The citation are in the judgment. Exhibit CW1/3 is the statement of account of the claimant, Ike Happy Uche, who testified as CW and covers the period 1st January 2012 to 31st July 2014. It is stamped and endorsed by First City Monument Bank Limited, printed on June 10, 2019. The statement of account of Happy Uche Ike, stamped and endorsed by Access Bank, which covers the period 10th October 2014 to 31st December 2015, and endorsed by Access Bank. Ike Happy Uche's account with EcoBank, stamped and endorsed by EcoBank, which covers the period of 24th April 2013 to 29th March 2019. And Ike Uche Happy statement of account with Union Bank, stamped and endorsed by Union Bank, which covers the period of 16th March 2018 to 30th May 2019. Given Section 12 of the National Industrial Code Act 2006, which enjoins that this court may depart from the Evidence Act when the interest of justice demands, I am satisfied as to the admissibility of Exhibit CW1/3, and I so uphold same. I so hold. Exhibit CW1/9 is a LinkedIn site featuring Augustine Chiedu. I visited LinkedIn site on 11th December 2022 via ng.linkedin.com or https://ng/linkedin.com. It transpired that LinkedIn is a social networking site designed specifically for the business community. The goal of the site is to enable registered members to establish and document networks of people they know and trust professionally. As a policy, minded by Section 12 of NIC Act 2006, this court relaxes the evidentiary requirement of Section 84 of the Evidence Act 2011 when computer-generated documents are in issue, admitting such a document but reserving the probative value for consideration in terms of the merit of the case. See Dorothy Adaeze Awogu versus TFG Real Estate Limited. Mr. Danson OOB versus Access Bank PLC. The citations are in the judgment. On whether a computer-generated document tendered by a party whose computer did not produce the document is admissible without need for certification as required by Section 84, Sub 4 of the Evidence Act 2011, the Court of Appeal heard in Stanbic IBTC Bank versus Long-Term Global Capital Limited and others, per Obande Festus Ogbuinya JCA. Thus, I'm quoting Justice Ogbuinya now. In Shafi Mohammed versus the state of Himachal Pradesh, the Indian Supreme Court was confronted with the interpretation of the provisions of Section 65B, Sub 4 of the Indian Evidence Act 2011 on the certificate required in electronic evidence. The Supreme Court of India heard. Accordingly, we clarified the legal position on the subject, on the admissibility of the electronic evidence, especially by a party who is not in possession of device from which the document is produced. Such a party cannot be required to produce certificate under Section 65B, Sub 4 of the Evidence Act. It certainly cannot be the intention of the legislature that Section 84 of the Evidence Act 2011 should strip a party who is not the owner or maker of computer-generated document of his right to present electronic evidence meant for the prosecution or defense of his case in a court of law. In effect, respondent's credit status report, CRS, as an exhibit, that is exhibit 1.2, I too welcome the document to the appeal. I take it with the deserved cap of admissibility. Close of quote by Justice Ogbuinya. Following from the authority of Stanbic IBTC Bank versus Long-Term Global Capital Limited and others, Supra, I am obliged to welcome Exhibit CW1/9 tendered by the claimant, and I so do. What remains to be done is the probative value to attach to the said exhibits tendered by both parties in court. And this is by evaluation of the pleadings and evidence adduced by the parties in this suit. Before I delve into the substance of this case, I must first remark on the written address of the parties. Aside from some typographical errors, grammatical errors pervaded the entirety of the written addresses, especially the claimants. And this was such that the word sick, S-I-C, in italics, was sadly strewn across the written address. In Eric Barrow versus Polaris Bank, His Lordship Honorable Justice Kanyip, PNICN, PhD, OFR, had this to say, quoting Justice Kanyip, the president of the court. I have had cause to denounce these grammatical errors and indeed advised counsel to take advantage of Chinua Asuzu's master classes. In Lucia, Balongu versus Voluntary Service Overseas International. This is what I said at paragraph 76. In Mr. Joseph Abang Bison versus Union Bank of Nigeria PLC, I denounced, amongst others, the long and windy sentences used by the writer of the claimant's final written address in that case, and recommended Chinua Asuzu's recently released learned writing, Padridge 2019, to him. I will do the same to the writer of the defendant's final written address in the instant case, and I do so with the following additional text by same author, the uncommon law of learned writing. I will do the same to the writer of the defendant's final written address in the instant case, and I do so with the following additional text by the same author. The Uncommon Law of Learned Writing, 2015, and Brief Writing Masterclass, 2017. It is disheartening that in this era of simple and user-friendly English, where the mantra as Chinua Asuzu put it in this text, write to be read, we see paragraphing of the sort used in the defendant's final written address in the instant case. As another mantra goes, a word is enough for the wise. In concurrence, I repeat the same admonition here to the claimants and defendants' counsel. A word, it is said, is enough for the wise. In paragraph 4.5, in paragraph 4.5 of his final written address, the writer of the claimant's final written address invited the court to see the following three cases: Mr. Godson Ihechukwu Nwukume versus First Bank of Nigeria Limited, Lillian Nena Kuma versus First Bank of Nigeria PLC, and Mr. Victor Omotosho Kundayo versus Federal Inland Revenue Service and others. In People's Democratic Party and others versus Barrister Chief Onyekachi Nwebonji and others, Court of Appeal heard per Oyewole, JCA, thus. Situation is further compounded and rendered bizarre by the fact that the judicial decision of this court said to have provided legal cover for the judgment of the trial court was an unreported decision, a certified copy of which was not produced before this court. There was no indication that it was produced to the trial court either, as it did not form part of the record of appeal. Said case ought to have been appropriately discountenanced. See Major General Kayode Oni, retired, and others versus Governor of Ekiti State and another, and Ugo Ngadi versus FRN, where Galinje JSC stated that where a counsel cites a case that has not been reported, he owes the court a duty to produce a copy of the judgment if he wants this court to rely on such authority. Where copies of the judgment are not produced, the court will have nothing to rely on. The cases are yet to reach this court. As such, I will refrain from commenting on them. I stand on the precedent duly adumbrated by my noble Lord Oyewole, JCA, in anticipation of the 3 unreported cases that the Claimant's Counsel has invited me to see. In the interim, I will also refrain from commenting on them. Exhibit CW1/4, dated 7th April 2011, is titled "The Condition of Service of Axon Group Worry." On the last page of the unpaged document, the addendum states that implementation of this condition of service should be backdated to the inception of the company. To the defendants, the claimant has failed to establish that there is a registered establishment called Action Group Worry, and the existence of Exhibit CW1/4, that is condition of service of Axon Group Worry, dated 7th April 2011, and its certificate of incorporation. On binding effect of the Court of Appeal heard in the case of Mrs. Janet Ude versus Civil Service Commission, Akwa Ibom State, and others, per Ndukwe Anyanwu JCA, thus. Parties, the trial judge, and the law cannot import any other term into the contract as in Exhibit A. Thus, where conditions of service exist between an employer and an employee, the provisions contained therein are binding on them. Any disciplinary measure taken by the employer against the employee upon the allegation of misconduct, such as termination of employment or dismissal, must be in accordance with the laid down procedure as provided by the conditions of service. That is, in the case of Exhibit A, DA Nigeria Alep Limited, as in the case of Exhibit A, DA Nigeria Alep Limited versus Oluwadare, see also Ogbaje versus Abuja Investment and Property Development Company Limited, which heard per Omoloye J that, quote, it cannot be the contemplation of parties that their relationship would become extinguished or fizzle out by reason of the appellant's appointment in Capital Hotels PLC, or by any reason other than in accordance with the procedure agreed and subscribed to by them in the staff conditions of service. Either party cannot waive or resile, this should be from the conditions of service by merely wishing them away or showing them away by a wave of the backhand. See the case of NRC versus Sumera. The only way they can be a waiver is by subscribing again to another written contract with new set of conditions and terms. See the case of Professor S.O. Abdurrahim and 3 others versus Professor J.B. Olufeogba and 43 others. The citations are in the judgment. I do not for a moment contemplate or fathom that the defendants would draw up conditions of service with retrospective effect, as indicated in the addendum. Secondly, by the authorities cited above, the law does not permit 2 sets of conditions of service running concurrently in a corporate organization. It is either that a new set of conditions and terms are drawn up and the previous one repealed, or the new conditions and terms are not made at all. I do not therefore ascribe any probative value to Exhibit CW 1/4 at all, and same is accordingly discountenanced entirely, and same shall not be considered for the purpose of this judgment. A look at especially reliefs 2 and 4 of the claimant, it would be seen that the reliefs are claims for special damages. Relief 2 is for the sum of 5,785,650 naira, less the sum of 2 million as his accrued emoluments, allowances, and gratuity. Relief 4 is for the sum of 2 million as cost for the filing of this action. The Court of Appeal in 7-Up Bottling Company, PLC versus Augustus is quite emphatic when it heard thus. Quote, the claim for gratuity, pension, housing fund, salary up to 24th October 2002, are all special damages and must be strictly proved. That is, each of the said items must be proved to the satisfaction of the court, as the court is not entitled to make its own estimate of same. It must be proved with credible evidence, and without such proof, no special damages can be awarded. See also NNPC versus Cliffco Nigeria Limited, which heard that a claim for special damages cannot succeed because it is admitted as special damages are never inferred from the nature of the act complained of. They do not follow in the ordinary course, as is the case with general damages. They are exceptional and so must be claimed specially and proved strictly. That the fact that it appears to be admitted does not relieve the party claiming it of the requirement of proof. Special damages are exceptional in character, and so there is no room for inference by the court. It is unreasonable to consider a claim for special damages reasonable in the absence of proof. Claim for special damages succeeds on compelling evidence to justify it and not on the sums claimed appearing reasonable to the court. See further, Onyura versus Onyura and another, Jibotosho versus RCC, UBA PLC and another, versus View and Trust Ventures Limited and another, Forte Oil versus Fidelity Finance Company Limited and others. The citations are in the judgment. Furthermore, the law is that all items of loss, that is, constituting the claim for special damages, must be specified by the claimant before they may be proved and recovery granted. See Mobile Producing Nigeria Unlimited versus Daiichus and others, Agbola and others versus ASB Investment Limited, Alile, oh no. Akile Sekab Daniel versus Akburan Oshi College of Agriculture, Yande. The citations are in the judgment. Additionally, the claimant has a duty to give specific particulars of the special damages he is claiming. This is to enable the opposing party know what he is to meet in the case. See Attorney General Anambra State versus CN Onuselugo Enterprises Limited. And Marine Management Associates Incorporated and another versus National Maritime Authority. The citations are in the judgment. Where can the claimant specify the items of law? There was a network challenge then. That was right. Where can the claimant specify the items of loss, the specific particulars of the special damages being claimed? Only in the pleadings. Relief 2 is a claim for the sum of 5,785,650 less the sum of 2 million as his accrued emoluments, allowances, and gratuity. Where in the pleadings did the claimant plead his accrued emoluments, allowances, and gratuity, and each item particularized as enjoined by law? Relief 4 is a claim for the sum of 2 million as cost of this suit. On award of cost, whether a claim is for the cost of engaging a counsel is grantable in Nigeria is debatable. See Riwane versus quotable. Guinness Nigeria PLC versus Nwoke. Wanyi versus Costa Services Limited. Ihekoba versus ACB Limited. The citations are in the judgment. In Mekunye versus Emirates Airlines, the Supreme Court stated that, quote, in a civil suit, a successful party is generally entitled to be compensated by way of cost, the amount of which the court has discretion to determine, regardless of whether it was pleaded and or proved, close of quote. Now, in paragraphs 9, 10, and 11 of the statement of facts, as supported by paragraphs 9, 10, and 11 of the written address or written statement on oath, written statement on oath of the claimant offered an explanation as to how the accident he complained of happened. In his words, paragraph 9, the claimant avers that during the period he was deployed to VMAT Company Limited by the first defendant, he was mobilized with a crew of 7 other personnel for a casing and tubular running job in one of the land rig at Okpia, Kwale, Delta State, on the 21st day of June 2013. Surprisingly, one Prosper Adagboa, one of the company's official mechanic, was assigned to drive the crew bus. And all inquiry as to the whereabouts of the company's official driver fell on deaf ears. Paragraph 10. Unfortunately, barely 2 hours into the journey, the driver lost control of the bus, which resulted in a fatal accident, which left one of the personnel dead and others, including himself, severely injured. Due to the severity of the accident and injuries, the claimant's leg was amputated. 11. The claimant avers that the first defendant owes its employees a duty of care to make sure that their working conditions is safe, and also to consult its employees on issues that concern them. Claimant also avers that an employer is vicariously liable for the negligence of its employees in the course of duty. From this pleading and its supporting the position of the claimant, The negligence that resulted in the fatality and severe injuries of others, including the claimant, whose left lower limb was amputated. That is sufficient explanation of the fact of negligence, and I so find and hold. The first and second defendants reacted in their statement of facts that the driver, Prosper Dabowe, is one of the crew members with his own job specification as a mechanic, as claimed by the claimant, and that Prosper Dabowe was also trained and formally designated / assigned as a driver to the first defendant. What the first defendant could not produce for verification, as argued by the claimant, is the driver's license of the said Prosper Dabowe. The defendant's argument that the claimant is the head of the crew and the most senior staff among the crew of the first defendant on that faithful day the accident occurred, in my humble view, does not take away the vicarious liability of the first defendant. The defendant had even averred with apprehension in paragraph 9 of his statement of facts that, quote, one Prosper Dabowe, one of the company's official mechanic, was assigned to drive the crew bus, but all inquiries as to the whereabouts of the company's official driver fell on deaf ears, close of quote. The principal, who can be vicariously liable for the tortious acts committed by his servant in the course of his employment in the instant case, is the first defendant, not the claimant, and I so hold. See Mrs. A.K. I. Theresa versus United Bank for Africa, PLC. The citation is in the judgment. Negligence is a function of the trilogy of duty of care. Breach of that duty and resultant damage. The authorities are clear that a successful plea of negligence consists of proving the trilogy. Negligence is also a question of fact, and facts are proved by oral or documentary or real evidence, or a combination of all or any of this. See section 131 of the Evidence Act 2011. See also Onawolapo versus ZTE Nigeria Limited, Heritage Bank Limited versus Dawn and Chike Nigeria Limited and another, ABC Transport Company Limited versus Omotoye. The citations are in the judgment. It is not in doubt that the claimant was employed by the defendants. It is also not in doubt that the injury complained of occurred when the claimant was at work for the defendants. In fact, the evidence is that it was the defendants that even took the claimant to the hospital after the injury. Under cross-examination, DW affirmed that he was not at the scene of the accident when it occurred. Chiedu Augustine, a staff of Action Energy Limited, that is DW, he, however, stated in paragraph 22 of his deposition that, quote, The incident was not due to first defendant's negligence, nor the driver. The first defendant driver did not lose control of the bus. Rather, he was trying to avoid an oncoming truck that was coming face to face with the crew bus. And as such, the bus, in a bid to avoid the said truck, skid out of the road and resulted to a fatal accident. Close of quote. For the DW to unabashedly embark on a crass hearsay testimony is most unconscionable. In law, it is hearsay and inadmissible when the object of the evidence is to establish the truth of what is contained in the statement. See Muhammad versus Attorney General of the Federation. The citation is in the judgment. I have no doubt whatsoever in the instant case that the defendants are negligent and so breached the duty of care it owes the claimant. I thus find and hold that the claimant has proved the requirement of breach of duty of care by the defendants. The last requirement is that the claimant suffered resultant damage. The fact of injury, that is the loss of the lower left limb of the claimant, is not in dispute among the parties. Exhibits DW6 and DW7 are detailed narration of the claimant's treatment of the amputated lower left limb. The requirement of resultant damages has thus been met and proved by the claimant, and I so find and hold. This being so, I find and hold that the defendant is liable to the claimant in negligence, the claimant having proved the trilogy of duty of care, breach of the duty of care, and resultant damage. The only outstanding issue is the quantum of damages to be awarded. The claimant is asking for 100 million naira as damages for negligence for the loss of his lower left limb. The case of SCC Nigeria Limited versus Elemadu, relying on Chaplin versus Hicks, held that the fact that damages are difficult to estimate and cannot be assessed with certainty or precision does not relieve the wrongdoer of the necessity of paying damages for its breach of duty of care, and it is no ground for awarding nominal damages. The case, relying on Ehidia Boya versus Dumez Nigeria Limited and another, went on to hold that in assessing general damages, the court has to consider what is fair and reasonable compensation for injuries sustained, and that previous awards made by judges in comparable cases can be relied upon. In the area of damages for personal injury, Hamza versus Kure and Edo State Agency for the Control of AIDS versus Osakwe and others, relying on Igreniovo versus SCC Nigeria Limited held that general damages are awardable for pain and suffering, discomfort and permanent scarring, and that no principle can be laid down upon which damages for such pain and suffering can be awarded in terms of the quantum. Claimant was hospitalized as a result of the injury he sustained from the accident, although it was the first defendant who paid the hospital bills. See paragraphs 1 and 14 or paragraphs 11 and 14 of the claimant's deposition. In Kenneth Igoshewe versus Data Steel Company Limited, the appellant had claimed in the High Court inter alia for permanent disfigurement of his finger next to the index finger and a partial disfigurement of the thumb. The Court of Appeal, after holding that, quote, it is equally trite that in assessing what is fair and reasonable, to bear in mind previous awards made by the courts in comparable cases in the same jurisdiction or even in the neighboring locality where similar social, economic, and industrial conditions exist. Close of quote. Reviewed the award of damages by the High Court, a higher figure, applying the principle set down in Idigbe versus Nnamani, which had similarly increased an award for personal injury to 10 million. This is 2022, and inflation has set in astronomical. Kenneth Igoshewe versus Data Steel Company Limited, citing a Jisun versus Ajao, itself enjoined that awarded damages for pains and suffering and disfigurement being a lump sum and a once and for all exercise must also, in order to be fair and reasonable, must also, in order to be fair and reasonable, take care of future economic loss, otherwise known as prospective loss, in order to keep up with the times, and in particular, with the economic strength or decline, as the case may be, of our national currency, the Naira. There is no taking away the fact that claimant has his amputated lower left limb to live with and be reminded of the accident for life. For this and just this, I award the sum of 15 million naira as damages to the claimant against the defendants. On the whole, the claimant's case succeeds in part and only in terms of the following declaration and order. 1, it is hereby declared that the defendants are vicariously liable for the negligence of their employee who caused the accident that led to the fatal injury suffered by the claimant, thereby leading to the amputation of his lower left limb. 2, the defendant shall pay to the claimant the sum of 15 million naira only as damages for negligence for the loss of the lower left limb of the claimant while on the way in defendant's vehicle for casing and tubular running operation at Okpia, Kwale, Delta State, Nigeria. 3, the said 15 million naira shall be paid within 30 days of this judgment, failing which it shall attract interest at 10% per annum. Judgment is entered accordingly.
I'm most grateful, my Lord, for a very, very well and awesome judgment. I'm very, very grateful, my Lord. I'm most grateful.
We appreciate the judgment of my Lord.
Yes. What is the next case? Is the judgment? Make sure you effect the small corrections. I need to look at the script first. Things I need to look at it. I mean the draft. So. The next case is NICN OCA/30/2015 Maritime Workers Union of Nigeria versus Chief Chukudi Ekwenze, Chairman Association of Engine Boat Operators, Marine Onitsha, Anambra State, for and on behalf of all the members of the association. Appearances?
Yes, please, my Lord, sir.
Yes.
S.I. Nanyere, Mrs. Nanyere spelled N-A-N-Y-E-R-E. Mrs.
Yes.
My learned friend. I am Asiebu. Mrs. Asiebu is spelled ASIEGBU for the claimant.
You are with who? Let me hear you well.
I am Asiebu.
Asiebu.
Yes, my lord.
What are the initials?
ASI.
S-I?
I-N.
I? For the claimant.
Claimant.
Yes, any appearance for the defendant? Defendant. Defendant. No representation for the defendant? You calling them? Hmm? Well, I take it that there's no representation for the defendant. You know the number of the defendant, counsel?
Good evening, my lord. My lord, I'm in UBA, not in this one. Even though I've not seen the cost list, I don't know the. I'm in Okabare against UBA. So I'll wait till it's my turn because I didn't see the cost list.
Which one is that?
Okabare and UBA.
So who told you is today?
It was, I got a message on my phone that is today.
Who is Okagbari? Huh? You're supposed to talk to the registry staff. I mean, the divisional registrar on that. You should have cleared with her first, not to be engaging me. You should have cleared first with the divisional registrar. Those are the places you make inquiries, not engage me.
No, my lord, I'm not engaging you. I came in, I sent a lawyer today. I got a text message that is for today by 9 a.m. And when my lawyer got to court, he was told that it's by Zoom by 4 o'clock. And we were given this link.
Which one is that? When they communicate. What? When? To who? Maybe it does not reach them. I understand. Hello, counsel.
Yes, my lord.
I understand a text message was sent to you yesterday. That is what one of the senior registrars is telling me here. They understand there was a text message sent to you yesterday.
That the judgment is coming up today by 9 o'clock. That's the text message I got.
Who sent that to you?
It's a number. I don't know. It's a telephone number. I don't know the name of the person.
Just quote the number. Let me hear. The number is what?
The number is
You see, you are interfering with my judgment. That is what I don't want. I have already called a case. So instead of delivering judgment, you are engaging me. That is why I told you that you discuss with the registry staff, not me. How can I call a case and then you start engaging me?
I'm very sorry,
Can
my
you
lord.
do that?
I will call the registry staff.
Then why did you disturb me? Why did you interrupt my judgment?
Because I was told
Because
that
I
my
was the
own
one
is
that
coming
sent
out
the
this
message
morning.
to you. When I
Did
already
they
called
say-
the case, second case I'm doing. Is that proper for you to do that? I finished with the first case. I'm calling the second case and you are engaging me. How is that proper to you as a lawyer? How is that proper to you? Because I'm tolerating you. You are talking. This is my judgment. I take it that counsel to the defendant is absent. I've carefully considered the processes and submissions of the parties. In the process of working on the judgment, it occurred to me that there is an issue of jurisdiction that needs to be addressed and determined. I invited the parties to address the court on whether the dispute in this suit is not a trade dispute for which the process of Part 1 of the TDA, that is the Trade Disputes Act 2004, should first be exhausted before the jurisdiction of this court in its appellate jurisdiction can be activated. In other words, whether the claimant is right to have activated the original jurisdiction of this court in filing this case as it did. Courts are today advised to decide matters on merit, even when they uphold objections as to jurisdiction, especially where evidence has been led or the matter was filed via the originating summons, citing Feed and Food Farms Nigeria Limited versus NNPC. The citation is in the judgment. Once again, on the supposition that I am wrong in dismissing this suit, I shall proceed to consider the merit of the complaint. But before I do that, I need to treat the issue of jurisdiction raised by the defendant in his final written address. That is, whether the claimant is a juristic person and has the requisite capacity in law to bring this suit. To the defendant, the claimant's name is not in the certificate of measure she tendered in proof of her legal personality in Exhibit CW6. That Exhibit CW5 does not contain the claimant's name thereon. The Constitution of Marine Workers Union of Nigeria, that it is not claimant's constitution. In reaction, the claimant maintained that it is a juristic person and has the requisite capacity in law to bring this action. That by Executive Governor of Kwara State versus Lawa, citation supplied, the juristic person consists of several categories, including natural persons, incorporated companies, corporations with perpetual succession, and unincorporated associations granted the status of legal persons by law. In determining the merit of the arguments of both parties on the issue of juristic personality of the claimant, I accessed wikipedia.org on 16th November 2022. And this is what I found. The Marine Workers Union of Nigeria, that is MWUN, is a trade union representing sailors, dock workers, and those in related trades in Nigeria. The union was founded in 1996 when the government of Nigeria merged 4 unions. That is 1, Dock Workers Union of Nigeria, 2, Ports Authority Workers Union, 3, Nigeria Union of Seamen and Water Transport Workers, and 4, Union of Shipping, Clearing and Forwarding Agencies Workers of Nigeria. Like all its predecessors, the union affiliated to the Nigerian Labour Congress, and by 2022, it had 83,479 members, close of quote. That is what I got from the Wikipedia. See also MWUN and 11 others versus Honorable Minister of Transport and 7 others. The citation is in the judgment. On this issue, I have no hesitation in finding that the claimant is a juristic person. The claimant I hold is a juristic person and has the requisite capacity in law to bring this suit, and I so do. The defendant had argued that payment of filing fees is a precondition for the court's assumption of jurisdiction, that where the filing fees are not paid, a court of law will have no jurisdiction to entertain the matter before it. That by Order 15, Rule 7 of NICN Rules 2017, the claimant has 7 days to file his reply. That by Order 57, Rule 5 of NICN Rules 2017, where processes are accepted for filing by default on the part of the officer of the court in the registry, such process shall become incompetent and shall not be allowed to be used for the purpose for which it was intended. See Onwubufo versus Okoye, Supra. To the claimant, its motion on notice was moved and granted by the court on 11th May 2017. The default fee was paid by the claimant as required under the rules of court. That Onwubufo versus Okoye, Supra, cited by the defendant is distinguishable and not on all fours with the facts of this case. In Sule and others versus Orisa Jimmy, the Supreme Court heard per Bagge JSC Das, quote, payment of filing fee is a precondition to court's assumption of jurisdiction in a case. The rules of court made this mandatory. See Onwubufo versus Okoye. However, the appellant's contention is not that fees were not paid, but that the appropriate fees have not been paid by the respondent. This is an assertion on the part of the appellants. Proof is required as to what ought to be paid and what was actually paid. The appellants have not proved that the assessment of the court's registrar was wrong. Neither did they state the amount that the respondent ought to pay. And in Igoyin and others versus Ajoko, Supreme Court heard per Ogunwumiju JSC that it is tried law that non-payment of filing fees is different from inadequate payment. While the former is the fault of counsel, the latter can be the fault of the registry. Non-payment of filing fee is a serious omission by the appellant, which in effect deprives the court of jurisdiction to hear the appeal. See Okolo versus UBA Limited. On the other hand, the inadequate payment of filing fee is usually the fault of the registrar who made mistake when he or she told the appellant the amount to be paid. In cases where the fees paid by the appellant are inadequate, it is the duty of the presiding judge to order the erring appellant or party to pay the correct filing fees instead of striking out the appeal or process. Close of quote. The law, as stated in Sule and others versus Orisa Jimmy, is that proof is required as to what ought to be paid and or what actually was paid as default fee. A perusal of the court's file indicates that the amended statement of defense was filed on 11th November 2015. The claimant's reply on defendant's amended statement of defense dated 13th June 2016 was filed on 4th October 2016. It was assessed for service at 320 Naira without an official receipt exhibited in the file. Counsel to the accused applicant then filed a motion on notice dated 13th December 2017, praying for an order of court enlarging the time to file their reply to the defendant's amended statement of defense, having been out of time. Filing fee of 470 made up of 200 Naira for the motion, 200 for service, 50 Naira for filing, and 20 Naira for oath, amounting to 470 was assessed by the registrar. At page 204 of the case file, however, is a copy of a receipt for 800 Naira issued to the claimant's counsel. To page 180 of the file is also the assessment of 29,700 as default fee for late filing of claimant's motion on notice for an order of court enlarging time to file its reply to defendant's amended statement of defense. There is also evidence of payment of default fee of 27,700 Naira on revenue collector's receipt number 8108193335, dated 11th May 2017. On the question whether the dispute in this suit is not a trade dispute, for which the processes of Part 1 of the Trade Dispute Act 2004 should be exhausted before the jurisdiction of this court in its appellate jurisdiction can be activated. This court stated the law in National Union of Hotels and Personnel Services Workers versus National Union of Air Transport Employees and one other, the judgment of which was delivered on July 4, 2019 by His Lordship, the President of this court. Honorable Godfrey Chukulum, a marina and beach owner, testified as CW. He later, what is that? Okay. Now, very often as in the instant case, especially inter-union trade unions disputes, is one over unionization and jurisdictional scope. And within a trade union, that is intra-union dispute, is one over check-off dues. The right to belong to a trade union is constitutional and statutory. See Section 40 of the 1999 Constitution and Section 1, Sub 1 of the Trade Unions Act, which defines the trade union as a combination of workers or employers, the purpose of which is to regulate terms and conditions of employment, and the right to deduct check-off dues as what is this? As of other deductions from a worker's wage is statutory, Section 16A of the Trade Unions Act and Section 5, 1, 2, 3, and 4 of the Labor Act. These rights are implied in and so are part and parcel of the terms and conditions of employment of all employees and workers. The law did not deem it fit to leave it to the vagaries of employers' conditions of service. So if these rights are implied into terms and conditions of service, why would a dispute over them not be a trade dispute within the definition of a trade dispute, especially given the definition of the term in Section 54(1) of the NIC Act? This being so, I only need to make a finding to that effect, and I will be perfectly within holding of the Court of Appeal in Road Transport Employers Association of Nigeria and others versus Mr. Olufemi, Ajewole, and others, to the effect that, quote, an inter and intra-union dispute would only be covered by the provision of Part 1 of the TDA if the nature of the dispute therein comes within the nature of the dispute said to constitute trade dispute under Section 48 of the TDA. Even if the view is taken that the present definition of a trade dispute in Section 48 of the TDA does not cover inter and intra-union disputes, which I doubt, and hence hold otherwise, in virtue of the use of the phrase any dispute between the employers and workers or between workers and workers. The point must be made that the definition of trade dispute in Section 48 of the TDA must defer to that of Section 54(1) of the NIC Act, in virtue of Section 53 and 54 sub 4 of the NIC Act. For all the reasons given, I find and hold that the instant dispute between especially the claimant and the first defendant over who can unionize the workers of the second defendant is a trade dispute. And I arrive at this finding and holding despite that my brother Tijani J of this court, a news rear, arrived at a different conclusion. Honorable Godfrey Chukulum, a marina and beach owner, testified as CW. He stated under cross-examination on 20th February 2019 that the claimant is a union which is higher than the defendant, which is an association, that the association has to come and join the claimant, not the other way. CW went on that the truth is that the defendant association was there before the claimant Marine Workers Union or Maritime Workers Union of Nigeria came in May 2015, but they were operating as individuals. That is why the defendant merged with the claimant. DW, however, countered that he was forced to join the Maritime Workers Union of Nigeria. By Abubakar Nafiu and another versus Ministry of Youth and Sports Development, and on the issue of whether a state government can interfere with day-to-day running and management of a body registered or incorporated under the Companies and Allied Matters Act. The Court of Appeal heard per Husseini, JCA, thus. The Nigeria Automobile Technicians Association, that is NATA, is by reason of Exhibit A attached to originating summons a body corporate having been incorporated or registered at the Corporate Affairs Commission on the 22nd June 1987. Hence, it has a distinct legal personality of its own, distinct from the first, second, and third respondents' hearing. See Solomon versus Solomon. And by reason of this distinct legal personality, the body of which the appellants are executive members, the first, second, and third respondents cannot interfere with the day-to-day running of the affairs of the body or organization, let alone for the first and second respondents, who are the representatives of Sokoto state government, to dissolve the executive of the outfit. It is ultra vires the powers of the first and second respondents to so act. Hence, Exhibit C and D attached to the originating summons, being the letter purporting to dissolve and appoint a sole administrator for the NATA, is of no consequence. The same being ultra vires the powers of the respondents. By dint of the corporate nature of NATA, the day-to-day running and management of the affairs of that body, including the dissolution of the executive members, is regulated by the constitution of the august body, the NATA, and other rules or regulations made thereto. See O'Neill Kusi versus RTC, MZC. See Akintemi, is it Akinteni or Tinkemi? Check. Akintemi versus Onwumechi. The citations are in the judgment. Respondents themselves have not challenged the existence of that constitution run by Nigerian Automobile Technicians Association, to which the appellants are members of the executive. See also Incorporated Trustees of the Assemblies of God, Nigeria, versus Reverend Joel Okogele and others, Akinloye, Akinyode, versus the Incorporated Trustees of Apostolic Church, Lagos, and Western/Northern Area, and others, Reverend Dr. Mrs. Nkechi and Nayo, versus Hoputaife, versus NASCO Estate Company Limited and others. The citation are in the judgment. The law, as stated earlier in this judgment, is that the right to belong in a trade union is constitutional and statutory. The law does not deem it fit to leave it to the vagaries of employers' conditions of service. The claimant's admission in paragraph 10 of its reply to defendant's amended statement of defense that claimant only extended a hand of fellowship to the defendant, which they gladly accepted, is a veiled admission to the defendant and his association to collapse into the claimant's union. By Exhibit CW1/8/1, CWA/2, CW9, and DW1, it is clear and evident that the claimant deployed unconstitutional procedures to compel the defendant to join the claimant's union. The erroneous assertion of CW under cross-examination that the claimant union is higher than defendant association, and the association has to come and join the claimant union clearly indicates the push of the claimant in this suit to unionize the claimant, the chairman and secretary of the Incorporated Trustees of Association of Onitsha Maritime Engine Boat Transport Operators. The police invitation of the chairman, boat transport owners, boat transport workers, Onitsha, dated 21/6/2013, that's Exhibit DW1, at the instance of the claimant, and the purported registration and affiliation of the association, dated 24/7/2013, that's Exhibit CW9, validates the pleadings of the defendant. So if these events are implied into terms and conditions of service or operations, the question to ask obviously is, why would a dispute over them not be a trade dispute within the definition of a trade dispute, going by Section 54(1) of the NIC Act 2006? For the reasons given, I find and I hold that instant dispute between the claimant and the defendant over who can unionize the workers of the defendant association is a trade dispute. For this reason alone, this case stands struck out. Assuming all I have said and heard amount to an error, I will proceed to the substance of the claimant's case, which basically is for monetary sums, special damages, declaratory and injunctive reliefs. This court had in Errand Express Limited versus Maritime Workers Union of Nigeria, the judgment of which was delivered on 26 March 2014, heard thus: a union has not been bequeathed with the right or appointed to police the word of work. A union, consequently, is not and cannot act as the policeman of labor practices in the word of work. Close of quote. This being so, I do not think it is within the locus of the claimant to ask for reliefs 2 and 3. Reliefs 2 and 3 are claims for a declaration that the claimant is entitled to the collection of proceeds from the economic and social activities within the Onitsha Maritime jurisdiction, having been so empowered at the rate of 20,000 per day to the final determination of this suit, an order of perpetual injunction restraining the defendants by themselves, their servants, agents, or privates, or otherwise howsoever, from entering or using the claimant's registered jetties or beaches within the Onitsha Maritime jurisdiction. The Association of Onitsha Maritime Engine Boat Transport Operators is, by reason of Exhibit DW2, that is Certificate of Incorporation of the Defendant Association, a body corporate, having been incorporated or registered at the Corporate Affairs Commission on 13th February 2008. Hence, it has a distinct legal personality of its own, distinct from the claimant. And by reason of this distinct legal personality, the body of which Okoro Sylvester, Ekwenze Chukudi, Madukolu Patrick, Joseph Ogugwo, Ofodile Ikem are the duly appointed trustees and executive members. The claimant by Godfrey Chukwukelum, Vincent Onora, Peter Osai Ozegbe, Chika Oji, and all their group cannot interfere with the day-to-day running of the affairs of the defendant association. It is ultra vires the powers of the claimant, its officers, by its officers or group to act. See Bethel, Ezebo, and others versus NUFBTE and another. See also National Union of Hotel and Personnel Services Workers versus National Union of Air Transport Employees and one other. Incorporated Trustees of the Association of God, Nigeria versus Reverend Joe Okogele and others. The claimant's averment in paragraph 10 of its statement of claim that, quote, she is no longer interested in doing any such collaborative activities with the defendant, hence they have refused to pay off the levies that are due to the claimants, quote, is in my considered view intemperate and incongruous with the law as stated in the authorities cited. It needs to be reiterated that by its pleadings and the evidence of CW, the claimant expressly admitted that the Defendants Association had operated at the Onitsha premises well before the claimant came on the scene. And by the authority of Abubakar Nafiu and another versus Ministry of Youth and Sports Development, SUPRA, the claimant does not have the local standard whatsoever to interfere with the day-to-day running of the affairs of the Defendant Association. The claimant's averment in paragraph 11 of its statement of claim that the defendant be restrained from entering or carrying out any economic activities on the registered jetties / beaches under the control or supervision of the claimant is unconstitutional. Claimant in the circumstance cannot act as the policeman of labor practices in the word of work, and I so hold. Reliefs 2 and 3 cannot accordingly be considered, let alone be granted. They fail and so are hereby dismissed. This leaves out reliefs 1 and 4, which are monetary sums and special damages, which the claimant said are payment of special damages. Claimant puts them thus: 100 trips of daily movement, 20,000 per day times 30 days, 600,000 per month times 4 months, 500,000 being cost of this action. Claimant averred in paragraphs 4, 5, and 6 of its statement of claim thus: 4, that the claimant, having registered the jetties and beaches in Onitsha, the defendant are mandatory, expected to make payments of levies in respect of their activities in and within the jetties and beaches under the control of the claimant. Claimant shall rely on the registered jetties / beaches form at the trial of the suit, and it is hereby pleaded, herein pleaded, that the claimant had enacted bylaws and rules, as well as an approved list of levies to be paid by those who carry out social and economic activities at the jetties, beaches within the maritime jurisdiction under the control/supervision of the claimant. The said approval list of levies is hereby pleaded and shall be relied upon by the claimant at the hearing of this suit. The claimant avers that the defendant and all members have indulged in carrying out the business of loading and offloading of goods and transportation of passengers from their aforesaid beaches/jetties, while neglecting to pay their accrued beach jetties levy of 200 naira per trip to the claimant. Claimant's averments were validated by paragraphs 5, 6, and 7 of its deposition. Claimant stated in paragraph 6 of its deposition that it had enacted bylaws and rules, as well as approved list of levies to be paid by those who carry out social and economic activities on the jetties, beaches within the jurisdiction of control and supervision of the claimant, that the approved list of levies is pleaded and marked Exhibit C. I looked at Exhibit C, dated 8th April 2014. It is headed Power to make bylaws, by rules and regulations of National Maritime Workers Union of Nigeria Constitution on approved union fund, quote, close of quote. It makes provision for fees for registration, ID card, stickers, tickets, proceed for a trip of sand, monthly check-off dues, inauguration fees, passenger loads, edible crops, wood, liquid volume of 200 liters, logs, affiliation, registration of association/organization. Appendix C also has fines/penalties for non-compliance on registration/ID, sticker, tickets, proceed from economic and social activities, and union fund, check-off dues/levies, inauguration fee, union constitution fees. That the bylaws regulation was adopted in the general meeting of the claimant union held at union office on 8 April 2014 and approved by the Delta District Central Zone of the union. Appendix C was signed by chairman and secretary. Black's Law Dictionary, 10th edition by Brian Garner, editor-in-chief, defines bylaw as a rule or administrative provision adopted by an organization for its internal governance and its internal dealings. Although the bylaws may be an organization's most authoritative governing document, they are subordinate to a charter or articles of incorporation or association or to a constitution. Emphasis the Judex. The Black's Law Dictionary 10th edition, page 1475, defines regulation as control over something by rule or restriction. Self-regulation, the process by which an identifiable group of people, such as licensed lawyers, govern or direct their own activities by rules, especially an organization's or industry's control, oversight, or direction of itself according to rules and standards that it establishes. Self-regulation is often subject to the oversight of various governmental agencies, such as the Securities and Exchange Commission, and the Commodities Futures Trading Commission. In Afdin Ventures Limited and others versus Chairman Abuja Municipal Area Council, the Court of Appeal heard per 2 JCA does. The question is, what is a bylaw? A bylaw is a rule or administrative provision adopted by an organization for its internal governance and its external dealings. Although the bylaws may by an organization be by an organization's most authoritative governing document, they are subordinate to a charter or articles of incorporation or association. The claimant's availment in paragraph 9 of the statement of claim that it is guided by a constitution and that the said constitution of the union shall be relied upon at the trial of this suit, and by CW's deposition in paragraph 10 that the claimant's constitution is pleaded and marked as Exhibit E is puerile and goes to nothing. This is because the claimant in its pleadings or CW in his evidence or cross-examination did not refer the court to any of its entitlement to any of the sums it claimed. A Mr. Mohammed Dunguns and others with its ENL Consortium Limited, this court first reiterated that the claimant who claims monetary sum succeeds only if he or she shows an entitlement. And an entitlement is shown by reference to the law that gives it. The collective agreement from which the entitlement was agreed or between the contracting parties, or the conditions of service governing the relationship of the employer and his or her employee. This court went on to stress that where a claimant made no attempt whatsoever to indicate to the court the exact provisions of the document they front-loaded that grants them the entitlements they claim, merely front-loading a document and saying that a right inures from it without indicating the clause, the section, the article or paragraph that grants the right is not sufficient. And cases can be lost just on this score. So as it is, I cannot grant relief 1. It fails, and so is dismissed. The claim for 500,000 as cost of this action and interest thereon are incidental or consequential damages. See Central Securities Clearance Systems PLC versus Udunoba. See FAAN versus Ahmed and another. See Vanguard Media Limited versus Bright Waters Energy Limited and another. Once the principal claim or claims fail, the incidental / consequential claims must equally fail. See Awoniyi versus Registered Trustees of AMOC, which held that a consequential order to be one is found on the claim of the successful party, and that it is difficult to conceive how a positive consequential order can arise from a claim which has been dismissed. And Emerson, Nigeria Limited versus Pedro Take, Nigeria Limited, held that where a court refuses the principal order sought, an incidental order cannot be made. See also Idigbe versus Ijayi, Chikere versus Okegbe, Polaris Bank Limited and others versus Olarewaju Oladipo. As it is, therefore, the claim for cost fails and so is hereby dismissed. On the whole, I do not see any merit in the claimant's case. It fails and so is hereby dismissed. Judgment is entered accordingly and make no order as to cause.
Thank you, my Lord. We are grateful.
We are grateful, my Lord.
Who are you?
I'm CEO Chibata. Network didn't allow me to come in. I am the part, counsel to the defendant in the judgment just read. By listening to the judgment, we are grateful, sir. CEO Chibata.
I'm not writing anything about you. I can't record you after my judgment.
As call places.
I heard you, but I cannot record you.
As call places. But we are grateful, sir.
Whether you can correct these things and bring to me today, because I need to sign it before I go. Yes, first thing in the morning. Today is 15. Yes. Sorry, the other one. What is this one? Next case is NHCN OCA/02/2020. Anthony Nwaise versus Union Bank of Nigeria PLC. Anthony Nwaise versus Union Bank of Nigeria PLC. Appearances?
Please, Your Lordship.
Yes.
PC Afuba.
Sorry?
PC Afuba.
PC.
Afuba, yes, my lord.
Okay.
I appear for the plaintiff applicant.
Okay.
May it please your lordship?
Yes.
Geraldine Ogundu.
Yes.
I appear for the defendant respondent.
Okay. This is my ruling. I have carefully considered the processes filed and the submissions of the parties. Order 49, Rule 15 and 16 of the NICN rule states thus. 15. The judgment creditor respondent upon service of the motion on notice may file a counter affidavit within 7 working days of the receipt of the judgment debtor application for installment payment. The court, on hearing the parties, may grant the application if the judgment debtor satisfies the court by exhibiting such willingness and readiness by the payment of the first installment at the hearing of the application. The respondent judgment debtor stated in paragraph 9 of its counter affidavit that by a letter dated 22nd April 2022, the chief registrar of this court wrote to the respondent returning the bank drafts earlier issued by the respondent with a request that the respondent revalidate the drafts. The respondent, in obedience to the request of the chief registrar, revalidated the bank's draft and forwarded Union Bank managers checks numbers 00. The checks numbers are in the ruling 000268 269 270 271. The sum of 10 million in 3 tranches and 4,756,609 naira 67 kobo to the registrar via this letter dated 16th June 2022. The letter with the drafts were delivered to the National Industrial Code on 6th July 2022 and was received by one Samuel Daly. A copy of the letter dated 22nd April 2022 is attached as Exhibit UBN2, while a copy of the respondent's letter dated 16th June 2022, together with copies of the bank drafts and proof of delivery, is attached as Exhibit UBN3. The respondent stated in paragraph 8 of his counter affidavit that on 3rd March 2022, the Court of Appeals struck out appeal number CA/E/449/2019, Union Bank PLC versus Anthony Weiss, on the ground that the respondent filed the appeal first before filing motion for leave to appeal. That following the ruling of the Court of Appeal on 29th March 2022, the respondent filed motion number CA/AW 90M/2022, seeking leave to appeal against the judgment of 31st May 2019, that the application is presently pending before the Court of Appeal. The applicant deposed in paragraphs 22 and 23 in support of his motion on notice that the respondent judgment debtor is a very viable commercial bank, that it has the finance to satisfy the judgment debt sum awarded against her in suit number NICN EN3 2013 of 31st May 2019, that the respondent judgment debtor will not obey or comply with the judgment of the court unless execution is levied on her. Looking at the deposition of the respondent, especially paragraph 8 thereof, I am inclined to surmise that the respondent rushed to file appeal against the judgment, knowing fully well that they were out of time. If not so, why would they hang up an incompetent appeal at the Court of Appeal before seeking leave of the Court of Appeal to appeal? That, in my candid view, was done deliberately to scuttle efforts at execution of the judgment against the respondent. That patently constitutes an abuse of the court process and to deny the applicant of the benefit of the fruit of his victory. It tantamounts to a malicious perversion of a regularly issued process. Be that as it may, I'm inclined to allow both parties to exhaust the processes at the Court of Appeal before this court may take appropriate action or directives in line with Order 49, Rule 22, Sub-Rule 2 of the NICN Rules 2017. The circumstance, leave to enforce this judgment and this suit cannot be granted. Same is accordingly struck out. Ruling is entered accordingly.
As God pleases. We are grateful, my lord.
As the court pleases, I'm grateful.
Take a second look. Correct the minor typographical. So that is all for the day. The court will rise.